On 17th August 2023, Buganda Road Court Chief Magistrate Ronald Kayizi allowed prosecution to take the file for review in High Court in the case filed by lawyer Asani Mabirizi against General Muhoozi, Kainerugaba and 7 others. Among the issues to be determined by High Court was whether the complainant Asani Mabirizi had locus to amend the charge sheet by adding more suspects, and whether the matter was amendable for review, and whether the laws were followed in transferring and taking the file from City Hall Court by the Director of Public Prosecution. Although this case was not right for review, Judge Michael Erubu determined the other grounds.
Clearly shows that the court's mandate when exercising its powers of revision is limited to the examination of the record of proceedings where the final orders have been made. It may reverse a conviction or acquittal or other order of that nature. That is orders that are final and not amenable to the alteration by the court of first instance. Orders that definitely determine the rights and obligations of the parties. This is the definition of final orders that is given in First Rand Bank Limited versus Mudingwa Harry Makareng. This is a Zambian case at page 67, at page 169, and the 8th edition of Black's Law Dictionary. The sum of it is that a revision is only meant for the examination and possible alteration of final orders. That position of the law is properly laid out in a guide to criminal procedure in Uganda by B.J. Odochi, 3rd edition, Law Africa, at page 270, which states, like appeals, that is I quote, like appeals, revision can only be founded on a final order or judgment of the court. It cannot be made against a preliminary or interlocutory order or ruling which does not determine the case. The courts in Uganda have long followed this precedent. In this case, the decision to allow the filing of an amended charge sheet was not a final order by any sketch of meaning. It did not determine the final outcome of the matter or the rights of the parties. It was merely a step taken to inform the court which additional persons were accused and what charges had been preferred against them. The decision of the court to allow the amendment of charges in this case cannot properly be the subject of a revision. It is vital to point here that if the interlocutory orders not determining the final outcome of criminal proceedings were amenable to revision, the courts may well be faced with a situation where there would be no end to criminal proceedings. Each decision of the magistrate's court would be open to applications for alteration by the High Court, because that would defeat the aim of ensuring that the criminal trial process in each case is swiftly brought to an end. Courts have steadfastly closed this avenue.
Basing his ruling under Article 120 of the Constitution, the Director of Public Prosecution's Office has a right to take over any case and at any time.
His complaint that his right to be heard was flouted is therefore unfounded. In his ruling of the 17th July 2023, the Chief Magistrate stated that he had intended to forward the file to the High Court for an evaluation of the proceedings. That would have been the correct course of action to take. This file is now before this court, and no court can sanction any illegality that comes to its notice. In the result, it is directed that the amended charge sheet filed on the 13th July 2023 was received in error and is accordingly struck out. The prosecution under the DPP shall proceed with the matter originally filed on the 11th November 2022.
Judge Michael Rubu said under Provision 171 and 221 of the Chief Magistrates Act, the Trial Magistrate Ronald Kaizi acted lawfully to take over the file from the City Hall Court.
It cannot transfer file to himself, therefore, is unattainable in light of the unequivocal provisions of this section. In the result, the Chief Magistrate of Buganda Road acted well within his powers to transfer file number 4530 of 2022 from the City Hall Court to Buganda Road and take over the proceedings. This power is part of the arsenal that enables the Chief Magistrate to execute his mandate in Section 221 of the MCA, which stipulates as follows. 1. A Chief Magistrate shall exercise general powers of supervision over all magistrates' courts within the area of his or her jurisdiction. 2. Without prejudice to the generality of subsection 1, a Chief Magistrate may call for and examine the record of any proceedings before Magistrates' Court inferior to the court which he or she is empowered to hold, and situate within the local limits of his or her jurisdiction for the purpose of satisfying himself or herself as to the correctness, legality, or propriety of any findings, sentence, decision, judgment, or order recorded or passed, and as to the regularity of any proceedings of that magistrate's court. This is a discretionary statutory mandate that enables the Chief Magistrate as administrative head to effectively oversee the judicial machinery in his or her jurisdiction. The magistrate cannot be faulted in any way for legitimately exercising a statutory prerogative to call for, transfer, and take over the hearing of the file. In this case, Mabirizi had a right to bring a fresh action or to be heard on an amended charge sheet. It is submitted further by Mabirizi that the matter had been fixed by the State Hall Court for hearing of his application for summons. I have perused the court file. There is no such record, but if indeed there had been one, then it would clearly be improper and unlawful. Again, because he had no locus, there was no requirement to serve the private prosecutor with the hearing notice.
However, court nullified the amendments made in the charge sheet by the complainant Asani Mabirizi by adding more suspects.
It is certainly expected that the DPP will act in the public interest and the need to prevent abuse of legal process when exercising this prerogative. It is partly because of this expectation that the DPP is not required to inform anyone, not least the person the matter is taken over from, of the reason for his action. It is also the position that a takeover may be done at any stage. In this instant case, it was argued for the Mabirizi that he had just filed the case and summons had not been issued. It was certainly not a bar as shown above. After the takeover, the DPP became the only proper party in the matter and assumed prosecution control. At that stage, the private prosecutor ceased to be a party and ceded all prosecution decisions to the DPP. He would at best be referred to as a complainant. If indeed he had any information he deemed relevant to the proper management of the case, then he was obliged to furnish such information to the DPP.
Court kicked out Asani Mabirizi in this matter, allowing DPP's office to take over the file. The complainant Asani Mabirizi vowed to appeal the ruling.
because Judge Lubu is contradicting himself. You cannot say in one issue that the matter is not amenable to revision. Then after that, you go ahead and revise the record that the parties were illegally added, that I had no locus. They are serious matters. For example, what about fair hearing? If I file my case and I'm in prison, you claim to take over and you don't serve me. Yet the court order the record was so clear that you serve the respondent. I mean, you serve the private prosecutor. The private prosecutor is not served. A judge in High Court is saying it's okay, even if he was not served. If you say a judge is free to come and walk to a chief magistrate grade 1 court and take over a file just like that without due process, then there's a problem. It means that as long as someone is able to compromise a chief magistrate of the area, then it's okay for him to come and take over the file and do whatever he wishes. There was no service. There was no proof of service. The letter from Kaizi indicated that the matter was fixed for 17th July. And there was no proof that I was served. So these are matters which the Court of Appeal shall handle. This is a simple file. It does not require a lot of recording like in normal murder files. I think before this week ends, the appeal will be there, and I think we shall get a date in the next criminal session to argue this matter.
He also highlights the reasons why on several occasions he objects to taking over his case by the DPP's office.
One, this DPP has been in habit of taking over my cases and killing them by bringing a nori. Contrary to the Constitution and the constitutional provisions, the Constitution is so clear, you take over and continue. So far I have more than 3 cases where our board has taken over and this continued under her hand. The fresh one is Chagulanyi's case at LDC court. Everything was clear. Makerere University are giving me certified copies of the academic records. They took over, they never came back to court. The time they came back to court, it was a withdrawal. I told the magistrate, don't withdraw this case. It's my case. If they are tired, let them go. She refused. The matter is now here at High Court. I filed a criminal case against Owunyidolo at Buganda Road Court. They took over mysteriously. Before I knew anything else, there was a nori, without even an explanation. Then Rajiv Parelia, Suduru Parelia's son, over degrading Lake Victoria in Entebbe. I opened a criminal case at Entebbe Chief Magistrate's Court. Everything was proceeding well. One time I came out of prison, I reached there was a nori. So it is, the DPP's office has been used to abuse the process, contrary to the Constitution. So if we cannot allow them to keep taking over our cases, and this is a matter which the Constitutional Court noted in Kaihura's case, that the Constitution tells you to take over and continue. But you don't even call me to give evidence, if not even a single witness, because at least if a single witness appears and fail to get other witnesses, then you can understand. But I don't even appear in those cases. They take over, they claim that now they are closing it. So we cannot allow them. That's why we are saying we are going to Court of Appeal.
Prosecution in this matter was represented by Ivan Chaze.